Hello, it's Roger Royce with the 10,000 Startups podcast. I am a emerging growth and venture capital partner with the law firm of Haynes Boone in Palo Alto, California. And today's episode is a brief summary of what's going on with the recent legal changes in Delaware. Now, you may recall from previous podcasts that we had talked about how Delaware about a year ago in early 2025 changed its laws in response to the Dexit. In other words, the companies moving out of Delaware into jurisdictions viewed as more friendly to management, such as Texas and Nevada, as places to incorporate. And in response to that, Senate Bill 21 amended the Delaware General Corporation Law, Section 144, to provide a little more certainty and a little more clarity to the law around fiduciary duties in an effort to stem the Dexit, we might say. Well, that law, and I'll get into it in a minute, was recently challenged, and recently the Delaware Supreme Court ruled and upheld the statute. So the bottom line is that the law, it's good law, and it is settled law now, Senate Bill 21. Now, as you recall, that bill was an amendment to the General Corporation Law relating to conflicted transactions and also the books and records section. But the main idea was basically to restore predictability, reduce litigation risk when we have interested directors and officers or controlling stockholders, because there had been some case law that had expanded the definition of controller or controller status and applied an entire fairness standard of review to those transactions rather than the more permissive business judgment rule that we always try to shoehorn into. So what the Senate bill did is it codified some rules. People are calling it safe harbors, but the statute doesn't really use that phrase, so I'd be careful about that. Let's just say there are some rules that eliminate equitable relief and monetary damage for fiduciary type claims from these conflicted transactions. So as a summary, remember the amended Section 144. Now it covers three categories of potentially conflicted transaction. One is when you have an interested director or officer. So for example, let's say we do an inside financing round and somebody's on the board that is making an inside investment, or it could be anything. Your imagination is your limit. A controller stockholder transaction, or a controller stockholder going private transaction. So the other thing is that the statute defined these terms: controlling stockholders, control group, disinterested director, disinterested stockholder. We used to agonize and do a lot of hand wringing over this because it was very fuzzy. It's whatever a court might decide those terms mean. We got good definitions now. So here's the procedure. We'll call them safe harbors for purposes of this discussion. So for an interested director or officer transaction, that's one where the director or officer is on both sides of the deal. They're voting on a deal on behalf of the company, and they're benefiting from the deal on behalf of themselves or some other entity that they have an interest in. So that transaction is protected. In other words, subject to the business judgment rule, if any one of the following is satisfied. You get a disinterested board or committee to approve. That's a committee of the board with full disclosure, or we get a disinterested stockholder approval. Again, fully informed, uncoerced. Now, if we have any one of those following, then the transaction can't be enjoined and people can't be sued for damages for fiduciary duty claims. And that's a fairly narrow exception, but it puts us back in business judgment and outside of entire fairness. The controlling stockholder transaction for a not going private transaction, which I'll talk about in a minute, that's an example. That's a transaction where a controller, that's a stockholder, controller, receives a non-ratable or unique benefit protection. Or unique benefit. In that case, they're protected if that transaction is approved by a committee of disinterested directors or approved by a majority of disinterested stockholders. And that is a major shift from the prior doctrine. Now, in the third category is less often, but what we call going private transactions. So if we have a squeeze out or a take private, then both those procedural protections are required. Disinterested special committee and a majority of disinterested minority stockholder approval. So this basically codifies previous framework for going private deals. Now, the law exculpates. That means it releases from liability, in effect, controlling stockholders from any monetary liability for these fiduciary duty of care claims. It's just for duty of care claims. But the loyalty claims, breach of a duty of loyalty or a bad faith claim or some disclosure violation, could continue to remain actionable. So the case that I referenced, the recent case that was just decided here in March of 2026, is Rutledge versus Clearway Energy Corp. And in that case, the plaintiffs challenged this law as unconstitutional. It said it stripped the Court of Chancery of equity jurisdiction, and it unconstitutionally extinguished vested fiduciary claims because of its retroactive application. But I won't get into all the details why, but the Delaware Supreme Court unanimously upheld the bill and answered both of those challenges with a no. So SB 21 is now settled law. So what does that mean as a practical matter? Well, number one, process matters. We want to get the process right. So that's great. Controller transactions are safe. And by the way, by controller, we have a definition of that now, as I said, and that means someone who owns at least 1/3 of the voting power and has the power to exercise managerial authority. And that prong is pretty critical because it does replace sort of this fact-intensive common law analysis. What it means is it excludes stock ownership below 1/3 by alone. Just stock ownership alone below 1/3 is not enough. Influence, prestige, deal leverage, that alone is not enough. Even contractual vetoes are not enough unless they amount to managerial authority. So really, control has to be real durable and directional. Is a good way to think about it. So controller transactions are safe if we follow the process, and going private transactions, as long as they're structured, we've got a good statutory roadmap. So we've got more clarity in Delaware. We'll see what it means in practice if it stops the Dexit, if companies will now continue to incorporate in Delaware instead of other jurisdictions, and a little more clarity in the law. This has been Roger Royce with the 10,000 Startups Podcast. Thanks for listening.